Uh, Alrighty then. Okay. A good morning and good noon to everybody here. Hello and welcome. So we're so glad you could join us today for our webinar. So this webinar is going to be rock solid IP for entrepreneurs, trademark essentials. My name is Joey. I'm Rob's executive assistant, and I'll be helping today in hosting today's session. So we all know how critical it is for founders and startup teams to understand how to protect their brands. And today's session is all about giving you the tools to do exactly that. I'm excited to introduce to you our speaker, Rob Wells. He is the managing partner of Rock IP PLLC, and Rob is not only a seasoned patent and trademark attorney, he's also an electrical engineer by training, and someone who has spent his career helping founders, inventors, and entrepreneurs build strategic, high-value IP portfolios. Rob brings a business-first approach to IP, helping startups make smart decisions about branding and protection from day one, so they don't run into costly problems later down the line. As we go through this presentation, please feel free to drop any questions in the chat, so no need to raise your hands or anything. This session is going to be recorded, and we'll be sending a copy of it to everybody who has signed up for it. It's going to be an estimated 30 minutes long, and Rob has graciously accepted to also do a Q&A session after the presentation, if you'd like to stick around and ask questions live. Okay, so I think that's it, and without further ado, I'll turn it over to the man himself. Take it away, Rob.
Thanks, Joey. All right, so to just kick this off with the initial legal disclaimer, this webinar is meant to be informative and educational, but it doesn't actually qualify as legal advice. If you have a specific trademark or branding question, we suggest consulting an attorney. But watching this webinar doesn't actually make us your attorney yet. With that, let's just kind of get into what we're going to cover today. So we're going to basically cover the basics of trademarks, Trademark 101, if you will. We'll talk about how to choose a strong and protectable mark. We'll talk about the importance of running a clearance search and possibly doing a naming project. We'll cover the basics of when and how to file for your trademark application. And then we'll talk a little bit about enforcement and avoiding genericide and some of the obstacles that we see a lot of our clients face, some of the more costly mistakes and how to avoid them. With that, let's cover the basics of trademarks. What is a trademark? A trademark is a source identifier. It is essentially the ability to recognize the source of a product or service. It helps to prevent customer confusion. If you kind of go all the way back to the Middle Ages, you get your blacksmith or your swordsmith, I suppose, in building a horseshoe or a sword, and they would literally put their mark on the sword that identifies them as the manufacturer. So, I mean, we drop in, we can talk about, Sir Ulrich Blackband. He's the blade master and of the Royal Guild. He's the guy who comes from generations of sword makers. He's making swords for the coronations, for massive duels. These are the swords that get passed down generation to generation. Well respected. You know that if you get a sword with his brand on it, you've got a valuable sword you'll be able to pass down for generations and give a valuable gift if that's what you wanted to do with it. By contrast, you can also go to Baldwin's 24-hour emporium, and you might get a sword that has a similar mark, but it's really for the knights who are in a hurry or those who don't really know any better. And there's potential customer confusion that can exist if you get that sword branded with the wrong mark. Now, imagine yourself kind of driving down the road and you start craving some McDonald's French fries. And you pull into that store that has the big golden arches and expect to get your French fries or your Big Mac. And you pull in only to find that it's actually a drive-through for McDougal's tire store. Imagine your disappointment and your frustration. That's precisely what trademarks are designed for, what they actually are created for, is to prevent the customer from being confused. In addition to that, your brand is also really valuable and can make or break your company. It provides an actual asset that is sellable and licensable, the same way that you might be able to license or rent out your your real estate or a product that you own. In terms of what you can actually trademark, the basics, the most basic trademark that you can get is what we call a character mark or a word mark. This is quite literally just the word, no stylization, no font, no design elements, literally just the word itself. When we file a trademark application in the United States, we literally file it in all caps, no exclamation marks, no punctuation, no spacing really even. The spacing doesn't even really matter in a word mark. It's just the words. By contrast, the next one is a design mark. This is when stylization actually does come into play. When you can introduce a particular font, you can possibly introduce a color, and where you can introduce stylized elements. For example, the Nike swoosh. Another very common trademark is the slogan. Sticking with the Nike theme, just do it. You can also file just do it as like we see it here, potentially with the stylization, but you could also file this mark as just, again, a character mark or a word mark. There's also a lot of non-traditional marks that get used and that are also protectable as trademarks. So, for example, colors. Colors get used to distinguish particular products and services. So, for example, I would assume that the ladies here in our audience probably recognize those shoes. Those are Louboutins, and they're very famous for a high-end fashion statement. And I suspect that just about everybody here can identify this box. It's the Tiffany's box, the Tiffany blue box, and is also probably more well respected even by the ladies in our audience than it is by the men. But the next kind of mark that gets used to protect goods and services is a sound mark. I suspect that we can all, let's see if you can catch this one. Short and sweet. There can be longer ones. You can have jingles, but that, of course, is the Netflix sound. Sound mark is protectable as a trademark. You might think of like the McDonald's jingle that we all hear, the ba-da-da-da-da. Also, again, a trademark and registerable. The next one is one of my favorites. Smells. I'll bet that everybody here can look at that and probably has kind of a visceral memory, a reaction to playing with Play-Doh and the way that it smelled. If mom ever made her own Play-Doh, or if you got the knockoff stuff in the store that wasn't branded Play-Doh, it just didn't quite smell the same. It wasn't the same. The way that Play-Doh smells is also a registered trademark. And finally, trade dress. This is going to protect the way that your products look and feel, the distinctive shape of them. So for example, here, we've got the Jeep with 7 slotted grille that you can identify just from a quick look, and those circular telltale headlights. All of these things are protectable under trademark law. As we get into what the actual power and brand of a trademark is, I wanted to point to this. This is from a company called Ocean Tomo, well-respected researchers in the industry. And this is a demonstration from 1975 up to 2020, demonstrating from the S&P 500 how things have changed from the percentage of value in physical assets, such as your brick and mortar stores, your employees and your products and services, to as compared to the intangible assets, your patents, your trademarks, your trade secrets, the things that are not physical. Between 1975 and 2020, 90% of the S&P 500's value is held in intangible assets, not in physical products or in physical assets. We're continuing to grow that way. And as a startup company, I'm sure that your value is also right along that 90% or even higher. All right, so what else? Your brand is an asset. It's a sellable asset, actually. So as you are establishing your brand and then potentially either needing to sell it, say, 9 out of 10 startup companies do ultimately fail. Hopefully none of you here would be in that category, but you certainly could be. And if that's the case, you might find that if you've established a strong and protectable brand, that you then have an asset that you could lease or sell or license, and it might provide additional revenue. Examples of that, Toys R Us was bought and purchased out of bankruptcy in order to go ahead and capitalize on just the brand, on the logo itself. Radio Shack is another great example of a company that was sold largely for its trademark rights so that it could be capitalized on, and it has continued to be a successful brand. Your brand can also create a moat, and that's part of the goal as you're starting to develop and establish your own brand. You're building customer recognition. And hopefully, as customers begin to identify you as a trademark owner and as a brand that they respect, you become synonymous, your mark becomes synonymous with the product or service that you offer, so that others coming into that market space actually have a challenge and a difficulty establishing themselves as a legitimate or worthwhile competitor. Hopefully you can establish yourself as a moat and develop that brand value. Now, distinctiveness is what really drives that value. Brand recognition and distinctiveness. In terms of distinctiveness, there are 5 levels of distinctiveness that are important. The most protectable, the most distinctive brand is what we call a fanciful mark. It is a coined term that doesn't actually exist outside of your brand. One example of that is Pepsi. Not a legitimate term. You're not going to find it anywhere in the dictionary. And therefore, it becomes the most distinctive potential mark that you can have. We encourage our clients to aim for a fanciful brand if at all possible, but there are other options. Right below your fanciful brand is an arbitrary brand. An arbitrary mark is one that is a term or word that does exist, but it represents something else other than the product or service that you offer. For example, Apple for computers. Moving right along is a suggestive mark. A suggestive mark is one that does intone or connote the type of product or service that you offer, but doesn't really describe it in full detail. For example, Netflix, a product that it's on the internet and it's where you might go to watch your flicks, your movies. When we start to get into dangerous territory is when we get into marks that are descriptive, especially if they're merely descriptive. This is a mark like, for example, Best Buy. Best Buy needed to be put on what we call the secondary register as opposed to the primary register until it became more distinctive. So a descriptive mark is one that actually does describe the product or services that you offer. Best Buy being, for example, a big box electronics store that sells products at hopefully lower prices, best prices. The least descriptive type of a mark, or the least distinctive type of a mark, is one that we call generic. A generic mark is one that anyone selling your type of product or service needs to use in order to describe the product that they are offering. For example, if you call your company Bread Co. for a bakery, it'd be pretty difficult for any other competing bakeries to use the term bread if you're allowed to register that mark. A generic mark will never be registrable. You will never be able to get a registration for it. By contrast, a distinctive mark or a descriptive mark could be registrable, but oftentimes needs to be put on the secondary register for a period of maybe 5 years in order to establish that brand. The strongest brands are in those first 3 categories. The categories that are the most distinctive, fanciful, arbitrary, and suggestive marks. So we encourage our clients to head that direction and try to choose a mark that falls into that category. So as you as a startup company are trying to evaluate and consider different potential marks that you might want to use, the question then becomes, how do you go about making sure that the mark really is available, that no one else out there is using it? And that comes to what we call a clearance search. A clearance search is one where before you actually file your trademark, we will go ahead and take a look at whether the mark is actually available or not. You can actually get a registration at the USPTO that is for a mark that isn't actually available. Someone else out there in the United States happens to be using the mark to describe their own products or services. So a federal registration does not equate to trademark rights or clearance search. When we conduct a clearance search is going to consider, yes, the marks that are already in the USPTO's database, but it includes other things. For example, business registrations across all 50 states. World Wide Web domain names. We'll check domain names to see if there's a registration on the domain name within your product or service area that might create a conflict to someone else who's already using it. and then just regular marketplace usage. I would have called these the yellow pages, but the yellow pages don't really exist anymore. Although the yellow pages were a registered trademark for quite a while. So you want to make sure that that mark is actually available. Now, the reason to check on and get a clearance search before filing an application is demonstrable with an experience that we recently had with one of our clients. We represent a brewery in North Carolina who called us and said, "Hey, there's another brewery in a different state that has the same name as us, and we need to put a stop to it." We contacted the other brewery and let them know that the trademark was registered and in use. Unfortunately, that company, the one that we contacted, they thought that they had just gotten a business registration and that was good enough. And they had registered a domain name and they thought that was good enough. They had spent hundreds of thousands of dollars in developing their logo and in getting signage, in marketing themselves on social media, and in buying glassware for their brewery, etc. Unfortunately, that was an expensive lesson for them. They learned that you do need to run a clearance search and make sure that the mark is truly available, and that just a business registration or a domain name availability doesn't actually mean that your mark really is available. So that's the importance of running a clearance search. If you'll run a clearance search before filing a trademark application, yes, it does increase the overall cost of filing an application. And I understand that, especially as a startup or entrepreneur, the funds can be tight. But if you consider the value or the cost that might incur if you find out that your trademark wasn't actually available, even if you got a trademark registration, the costs that you would lose in wasted branding spend and having to rebrand and fighting an opposition or a lawsuit, etc., those are going to far outweigh the cost of $1,000 or a couple $1,000 to run a clearance search in advance to make sure that you actually do have clearance on that mark. Now, one of the ways that we talk about with our clients proceeding is to go ahead and run what we call a naming project. Too frequently, we find that our clients engage their marketing department or the CEO. If that's you're running a small shop, they go ahead and choose their mark. They pick it, they get invested in it. They might even start using it, and then they will come to us and ask us to go ahead and run a clearance search or to register the mark. And when we do, sometimes we deliver bad news and have to let them know that the mark is already taken. At that point, marketing has already been done. You've already invested quite a bit of money, and it can be difficult to go ahead and make that change at that point. We recommend something that we call a naming search. This is one where maybe you have your marketing department come up with 3 or 4 different names and provide those to us. We'll run a knockout search on all of them, and we'll provide you with kind of a linked or a rated grouping of those names to show you which ones are available, which ones aren't, and which ones are going to be the strongest mark for you. At that point, then you can pick your favorite one of them. We'll run a full clearance search on that one and confirm its full availability, and then we can proceed to filing an application. The next question becomes whether you're going to file your mark as an in-use mark or as an intent-to-use mark. One of the advantages of getting into filing your trademark applications early is that you can actually file an application to protect your mark before you ever start using it. The benefit to doing that is that you know you have the mark, and anybody else who comes in kind of right at the same time won't be able to register your mark. We have a client actually right now that ran a clearance search. We verified the clearance of that mark and then found out that a fairly large company within a 1-week period of time of them actually using the mark also filed their intent to use mark. So it is important to kind of keep the ball rolling and make sure that you're taking action on it fairly quickly, even in advance of starting to use the mark. The next question you have is one of whether you're going to pursue a word mark or a design mark. So that character mark that we talked about earlier, or a design mark, the logo. Again, for startup companies who may have tighter budgets, we always suggest pursuing a word mark first. The reason for that is that the character mark, or the actual lettering, absent of all the design elements, can still be protected if it's used in a design mark. It's just the characters, and even if used in a design we can still protect it and we can still enforce it. By contrast, a design mark is going to protect those stylized elements. So if you have if you went with Nike, but you didn't protect and you protected the swoosh and the stylized version, but some other competitor came out and had it in just a different format, they would be able to use that mark in a different design without necessarily infringing your mark. So the strongest mark that you can get initially, at least, if you have to make that decision, is going to be in the word mark area. We also, of course, do recommend filing a design mark, but if you have to make the choice between a word mark and a design mark, it's a clear choice. Go with the character mark if at all possible. When you file your mark, you'll have to decide if it's a design mark. You do need to decide if you want to claim color or not. You can claim color or not claim color. If you don't claim color, you can enforce your mark under any color scheme. So you might think about your own mark or a logo that you're aware of and realize that you might apply it in different types of color formats. If it's on a white background or on a business card, you might show your mark in black, or you might show your mark in a totally different color if it's on the window and a different color scheme. I'm sure that all of us know that we've seen the Nike logo in any number of different colors. So we recommend not claiming color, at least initially, unless color is the hallmark of your mark. For example, that Louboutin shoe or the Tiffany's box, where color becomes a really important part of the mark. You can proceed to go ahead and file your mark again later once you've received your design mark without color, if there's a particular color scheme that you want or that you really like. Then the next part in filing your trademark application is going to be choosing a particular class of goods and services, possibly multiple classes of goods and services. In the United States and abroad, there are 42 different classes of goods and services. And those classes of goods and services, those protect all sorts of different, any sort of different products or services that you might have. And your trademark attorney can help you to make a decision about which classes or class your trademark application falls into and should be protected. One of the important things if you're a SaaS company, for example, is that you might have to file under two different classes for downloadable software and also for non-downloadable software. Those two, for some reason, fall into two different classes. Again, your trademark attorney can help you make that decision and figure out whether you need to file in multiple classes or just a single class. The next question to ask yourself is whether you're going to need foreign protection for your trademark. If you're a dry cleaner in Cincinnati, for example, you probably don't necessarily need to get trademark protection in any other country. By contrast, if you're going to sell cleats or soccer balls, you probably want to go ahead and protect your mark in Latin America and probably throughout Europe and maybe some other countries as well. The way that that works is that you can get and claim priority up to 6 months after you have filed your trademark application in the United States. So it's important to keep an eye on that deadline and make sure that if you're going to file in any other countries, you file those within that 6-month timeline. So again, that's within 6 months of filing your US trademark application. You can also always file in any other country wherever you want to at any point in time after you've filed to begin with. But the benefit of filing your Madrid Protocol application is that you get to claim the benefit of priority to that initial trademark application. So you get that date of first use. In the United States, we protect marks based on a first to use, but there are other countries throughout Europe and China and even throughout Latin America that actually provide trademark rights on a first to file basis. So it's important to keep that in mind and remember that just because you're the first to use it here in the United States doesn't necessarily mean you'd be granted the trademark in another country. Unfortunately, we've also seen that there are foreign entities that try to go ahead and capitalize. They actually watch the U.S. Trademark Registry, and as soon as you file in the United States, they file abroad just in order to get your trademark and potentially kind of play on your mark in their country. So that's another important thing to keep an eye out for. All right, let's talk about some of the mistakes and how to avoid them. And let's talk about what's important once you have your mark. Now, first of all, when you use your trademark, remember to utilize the TM and the registered R logo as appropriate. what's appropriate and when do you use each one. Again, your character mark or your design mark should include these, whether it's on the logo itself or just in written correspondence when you're referring to it as a trademark. And again, trademark use is when you identify the product or the service that you offer. The difference between the TM and the registered trademark logo is that a TM logo just indicates that it is a trademark, whether registered or not. And the registered logo indicates a trademark that is actually registered. That R logo is applicable in all countries. It applies to countries here and in Latin America and China and throughout Europe, etc. Be aware of scams. As soon as we file your trademark application, you will almost certainly get a letter or a phone call or an email from somebody who tries to convince you that you need to pay them thousands of dollars in order to have your mark registered in a database. It will look and sound as though it's legitimate and as though you need to pay extra money in order to preserve your trademark rights. You don't. There are, unfortunately, scams that are set up to take advantage of unwitting brand owners. Unless it comes from your attorney or unless it comes directly from the USPTO, there's not anything there that you need to worry about in terms of paying additional fees, and you can ignore it. You can also just go ahead and send the letter to your attorney, and they'll be happy to go ahead and let you know whether it's protectable or not, or whether you need to respond to that or not. Maintenance and renewal requirements are important and an area where we see a lot of our clients actually take a misstep. Once you're given a registered trademark, there's going to be a couple of different maintenance or renewal fees or renewal deadlines that need to be filed. The first happens between years 5 and 6 when you need to file what's called a section 8 and 15. And the second is one that is that takes place at years 9 and 10 and then every 10 years after that. There's a fee that's required and a declaration that indicates that you're still using the mark. Unfortunately, our clients, a lot of clients, and we've seen it happen repeatedly, they just kind of don't remember at years 5 and 6 or at years 9 and 10 or at years 20 and 21 to remember to go ahead and pay that renewal fee to maintain their trademark. It might be something that they put on the calendar and then just forgot about, or it might be an employee who was tasked with the responsibility to go ahead and pay that fee, but that employee moves on and now nobody remembered to get it renewed. What we suggest is go ahead and rely on your attorney to remind you of those deadlines and take care of those fees. It's a lot less costly to have that attorney go ahead and remind you and take care of the fee than it would be to unfortunately have to re-register your trademark and file the entire application all over again. Now, once you've got your mark in place, you do, as a trademark holder, have an obligation to police and enforce your mark. And what that means is taking note of anyone else who uses your mark improperly, who you haven't licensed. Typically, the beginning of that is enforcing your mark. Your trademark attorney likely also has resources to automatically monitor and then go ahead and try to enforce your mark. And it may well be worth offloading that responsibility to your trademark attorney and relying on them to help you police and enforce your mark. And the final thing, make sure that you're an adjective and not a noun. You can suffer genericide if your mark gets used to describe an entire category of marks. So be the Cadillac of whatever product or service. Be the well-known mark in a category. Be Jeep, be Porsche, be Nike, be you. And don't let your mark become synonymous with an entire category. We've seen marks that have disappeared over time because they became generic. For example, Kleenex and aspirin and Xerox. You don't ask for a facial tissue, you ask for a Kleenex. That mark has become generic. Aspirin, similarly, has become synonymous with a painkiller. And Xerox, you don't ask for a photocopy typically, you just ask for a Xerox. Coca-Cola is famous for having discovered that in the South, you would just order a beverage, you would just get a soda by ordering a Coke, and that might mean root beer or orange or Sprite. And they engaged in a large campaign to enforce their mark. So be careful and make sure that you have brand guidelines to enforce and maintain your mark. Those are the very basics of Trademark 101 for entrepreneurs. there's, I'm sure, a ton more, and we'll probably go ahead and host another webinar to get even more into the weeds. But with that, Joey, I'm going to turn it back over to you, and let's take a few questions.
Okay. Awesome job, Rob. Thank you so much for presenting that. That was very informative, but the fact that it's still just like a very brief introduction to trademarks just shows how much people really need to know more about trademarks and IP in general. Okay, so let's go ahead and get started with the Q&A portion of this. So I know I saw Catherine had a question earlier. She put it in the chat. So she's asking, if you have a name that is similar to other trademarks and someone else owns that name, is is the next step to go to design? Her thinking is that so the stylization of the words, the name, and with the color and font are your differentiator.
Yeah, that's entirely possible. But also be aware that that does kind of, lessen the strength of your mark. If other brands are also in the same space that you are and have a similar mark, that can threaten the value of your brand. So it's wise to consider both whether or not your brand becomes strong. Can you create another mark that isn't conflicting with any other marks? But that aside, if there are other marks that are just close and you're comfortable in that space or you've already been using a mark, then yes, we would say that the next place to go is to pursue a design mark that is distinctive. And possibly, like you said, go ahead and protect color.
Okay. Thanks for that, Rob. Hopefully that answered your question, Catherine. For the others, we're opening up the floor. You can just type it in the chat box if you have any other questions. But right now, I have some questions that were sent in. Some people who wanted to attend, but unfortunately could not find the time to. So one question that came up was, do people need to trademark their business name and logo separately? Or would you advise that if they have like the financials to do so, they do it at the same time?
That's a great question. We would actually recommend protecting the character mark and design mark at the same time if the funds allow. But we also understand that that's not always an option for all startup companies who kind of live in, living day to day and penny to penny. So if you have to make the decision, go with the character mark first instead of the design mark. But if you can do both, definitely pursue both the design mark and the character mark at the same time. And anybody who wants to can feel free to go ahead and raise their hands, and Joey can, feel free to ask your question out loud too. That's just fine.
Yeah, definitely. People can just feel free to, unmute yourself and talk. And I see Catherine raised her hand. Go ahead,
Yeah,
Catherine.
I'm gonna get all my questions answered here. Rob, I did not file within 6 months of some of my filings to think when I was thinking about, well, I wasn't thinking about international expansion at that time. So what I know that you'd want to know case by case, but if I'm pretty sure I'm past the 6 month mark, what does a person have to do?
Okay. So at the point when you are after the 6 month mark, then you don't get to claim priority anymore. And that's unfortunate. But we would still say, do file the foreign trademark application. And you can even still file it under the Madrid Protocol. You just don't get to claim priority. So when we file under the Madrid Protocol, there is one particular fee that gets charged, and you just pay the fee for examination in each of the countries where you want to register. What you'll get back is a notice that the registration has taken place, and then you'll basically pursue that trademark in each of the other countries. And hopefully nobody else has already caught on and tried to register your mark in those countries.
Okay, thanks. I'll follow up with you about that for sure.
That's great.
Right. Thanks for that, Catherine. And Brian has a question here also, as well, Rob. He asks, how much should he budget for a clearance and trademark filing?
That's great. So typically, what we find is hopefully you don't have to run multiple clearance searches. It's always best when you don't have to run multiples. But what we typically suggest is right around $3,000 to clear and file an application to register your trademark. And then that process, that'll probably be pretty much upfront. You'll pay that fee kind of right away on the clearance search and then on the application. then you'll probably wait. And right now, with the political climate the way that it is, you'll probably wait about a year before you see the application get taken up by an examiner. Usually when we file those applications, you're not going to see any additional costs, but there is a possibility that we'll need to respond to an office action or argue, especially if you choose a mark that's in that lower category. If you pick one that's lower on the distinctiveness scale, when it's just merely descriptive, or if you're trying to use a person's name in the mark and need to disclaim that.
All right. Thanks for that answer, Rob. Let's go back to another question that somebody emailed. He was asking what happens if somebody is already using a similar name or the same name, but it came up in let's say in a clearance search that they haven't actually trademarked it. What would you advise in that kind of scenario?
Yeah, that's a valid question. In the United States, again, we give trademark rights not to the first person who registers or files an application, but to the first person who uses it. The benefit of filing a federal registration to register your trademark at the USPTO is that you are deemed to have a presumption that you are the senior user. So if there is ever a debate about who was the first one to use the mark, you're presumed to be the senior user, and then it's on the other party, the ones who didn't file their application, to go ahead and establish that in fact they are the senior user. But that doesn't save you from, that doesn't put you in a position where somebody else is using the mark and but you have the registration and therefore you get the mark. Like we talked about a little earlier, that's the important running a clearance search. If you don't run that clearance search and make sure that nobody else is using it, somebody else might be entitled to the mark, and you would then have to rebrand, even if you have a federal registration.
All right. Thanks for that, Rob. I'm wondering if anybody else has any questions. Feel free to unmute yourself, raise your hand, or just type it in the meeting chat. We have a few minutes before we can close out this webinar.
Any questions? We will go ahead and circulate the 10 keys and a checklist of entrepreneurship and trademarks. We'll also go ahead and circulate a copy of the webinar and the slides so that you'll have them probably tomorrow morning.
Yep, we will. We do have one final question that was sent in prior to the start of the webinar, Rob, and is it possible for you to get a trademark on a name that some other entity is already using, but in a different industry?
Yes, absolutely is. You can file a trademark in different classes. So for example, let's take Apple. Apple has their trademark covering electronics. There's also in Northern Virginia a credit union called Apple. Their logo doesn't look the same, but the mark is the same. You can get a trademark in an entirely unrelated field. You can still go ahead and you'll face a rejection if the classes are close, if there might be similarities. Again, what we're looking for is the likelihood of confusion. We want to avoid a likelihood of confusion. So if, for example, there's Apple for electronics and that kind of thing, but then you file one for podcast or something closely related to that consumer electronics industry, you might still face a rejection for a likelihood of confusion. There's also the other thing to consider is, just like I showed you in that example with the McDonald's French fries, there are marks that become so distinctive and so well known that it really doesn't matter what industry you're in. If you copy their logo, especially, you'll face a challenge and you may face a rejection, or you may face a need to rebrand. So for example, don't name your tire company McDonald's or use the golden arches.
I see. So basically that kind of flexibility in trademarking it in a different industry only goes for character marks and not necessarily design marks. Is that right?
Typically the logo is where you're going to face the most challenge. But so you might be able to get away with calling something, again, Best Buy. It'll be easier to find a distinguishing to distinguish among two similar brands that are in different areas where you're getting more into the descriptive marks. When you're in the more distinctive marks, the fanciful or the arbitrary marks, it's a little bit more difficult to register those. So, you know, if somebody had Pepsi and they were using that to try to protect their you know, their CD players or whatever it is, they would probably still face a challenge.
Thank you so much for clearing that up, Rob. Okay, so I think that was it. If nobody else has any questions they'd like to bring up, going once, going twice. Okay, I think that was pretty much it. So let me go ahead and close things off. So thank you so much, everyone, for being here with us today. We really do appreciate you taking the time to learn more about trademarks and how to protect your brand the right way. A huge thank you again to Rob Wells himself for sharing so many valuable insights, and to all of you for the great questions during the Q&A. So we hope this gave you a clearer picture of what to watch out for and how to take those next steps in securing your IP. So this session was recorded and we'll be sending out the replay soon. Keep your eye out in your inbox for that if you want to review anything or share it with your team. We'll also be sending a PDF version of Rob's slides as well as the promised exclusive 10-point checklist to start up trademark success. And, you know, this is just the beginning. We're planning to keep these conversations going with more webinars like this one, so stay tuned. And we'd love, of course, to have you join us again. But until then, take care, and thanks for spending part of your day with us. Bye for now, and see you sometime later.
Thanks, everybody.